In this judgment, Supreme Court has overruled one of its previous judgment, the citation of which is 2024 SCMR 1496. Brief facts of the case are that the High Court, in its appellate jurisdiction, has dismissed the suit solely on the ground that the party has failed to deposit a balance consideration at the time of filing or instituting a suit, and later on they did not file an application to do the same thing. While making this decision, the High Court relied upon a previous Supreme Court judgment in which it was held that it is mandatory upon the party who seeks specific performance under the Specific Relief Act that at the first appearance before the court they must deposit a balance consideration or they shall apply for the same thing. The matter was appealed before Supreme Court. Now the legal question before the Supreme Court was whether there is a mandatory provision under the Specific Relief Act to deposit a balance consideration or shall apply the same thing. Whereas it was held that the wisdom behind a balance consideration is to secure a willingness of one party to perform their part of obligation. Otherwise, there is no such provision in the Specific Relief Act that makes an obligation on the party who seeks specific performance suit to deposit a balance consideration at the time of instituting or filing a suit, or later on they have to make an application for the same thing. Unless the court has ordered, and even if the party has failed to deposit a balance consideration in the stipulated time, then still the court has a discretionary power to enlarge a time under section 148 of the Code of Civil Procedure 1908. Hence, the Supreme Court set aside the orders of High Court and remanded the case. What we have learned from this case is there is no statutory obligation on us to deposit a balance consideration at the first hearing of suit. This judgment is very useful for the contractors, the party who is going to file a suit of specific performance, and the parties who are already litigating. Thank you.